My name is Federico Vasoli. I'm originally qualified in Italy, in Milan, at the Bar of Milan, and I am the managing partner of my firm, which is called the MTV Global. So my firm has offices in Malta, in Singapore, and Vietnam, in both Hanoi and Ho Chi Minh City. I have witnessed myself too many cases of, say, I'm just inventing the nationality, but say Italian clients having commercial disputes with, say, Vietnamese suppliers or clients, that even if they were right, they couldn't enforce their rights. They couldn't have their rights protected simply because they did not write a proper arbitration or other form of alternative dispute resolution clause in a properly drafted, valid and enforceable agreement. So that goes back to the basics of doing business internationally. That is, you must have a written agreement in place that is valid and enforceable. Unfortunately, too many businesses do not have something like that in place, and that is
Federico, excuse me. Speaking of written agreement, even in Singapore, the agreement should be in written.
Yes, the basic thing is that arbitration or alternative dispute resolution, so if you want to include mediation and the other forms of dispute resolution, are a form of sort of private justice. So they replace the ordinary mechanism, meaning that if you want to replace the standard public forms of justice that is going to court, you need to agree to that. Both parties need to agree to that. Now, there are countries like Singapore, like England, and others where you can agree at a later stage to do so. So you have a legal dispute and you decide in writing that you're going to resort to arbitration if both parties are reasonable. But it could, in other countries, this is not possible. So you have to agree in advance. And in any case, it is best to agree in advance anyway, because the other party to the contract may simply delay the resolution of the dispute by saying, no, I'm sorry, do not agree with going to court, with going to arbitration, sorry, so let's go to court anyway, and you're stuck. So yes, it is important to have it in writing in advance. Normally, you would include an arbitration clause or a similar clause, a mediation clause, whatever, in a written agreement beforehand. So as I was saying, if you're right, and even if you go to court, let's say in Italy, and you win your case against the Vietnamese, or the other way around, you go to court in Vietnam and you win your case against Italy. I'm not making it a matter of who's right or who's wrong. The problem is having the sentence properly executed in the other country. Assume you are in Italy and you go against a Vietnamese supplier that has sold you defective goods. What do? If you go to Italy to court, you may win the case, but then enforcing the sentence, executing the sentence that is in your favor from Italy in Vietnam is a massive headache, massive bureaucracy, really difficult, etc. The other way, you want to go all the way to Vietnam to court, good luck. You need to have all proper pieces of evidence in place, etc., in order to make sure that the local judge understands what you're talking about. And that goes back to the basics again. That is, if you do business without a properly drafted agreement, how can you prove in court that you are right? Imagine you are a foreigner, you go to a distant country like Vietnam, and you have to convince a judge that you're right. And in fact, you are right, but you have to prove it. How can you prove it if you don't have a contract and if you don't have all evidence that proves that you are right? If you go for arbitration instead, first of all, arbitration is more standardized in a way that is, it is something that is more international. So it bridges cultural gaps. Secondly, it is normally faster than going to court. It happens more frequently than one may think. I have a client here in Malta that had a commercial credit against an Italian company. The Italian company went bust. It's been at least 4 years. It was years before the pandemic. So it must have been 2017, 2018 that the procedure started. The company went bust. They didn't have an arbitration clause in their agreement. And now there is nothing to recover because it's not even the debtor's fault. They went bust. There was a pandemic. They couldn't sell their assets. That's it. Had they gone for arbitration, I'm not saying that this is a bulletproof mechanism because nothing is bulletproof in the legal systems, but they would have certainly protected their rights better. So there are many places where you can go for arbitration. Singapore, I have not forgotten your question, is one of those. You have the Singapore International Court of Arbitration, which is a very prestigious, famous, and widely used venue for arbitrations. It's not the only one, but yes, in Southeast Asia, not just in Southeast Asia, it is widely used. Very quickly, in all the countries that I mentioned, so Italy, Malta, and Vietnam, with the exception of Singapore, ordinary justice is generally slower than arbitration already are. So the big advantage is that normally arbitration procedures are faster. Then, of course, it can be tricky because you need to enforce the arbitral award, and there could be challenges of its legitimacy that are posed under a strict legal standpoint by the defaulting party. But let's not get into that. The quick answer is, with the notable exception of Singapore, whose legal system is quite fast, whose judicial system is quite fast and efficient, in the other jurisdictions that I cover, arbitration and in general ADR are faster. The other advantage is that it can also be more specialized than an ordinary court. Because if you go to court, you have a judge that is, or a panel of judges that can be well prepared about the law, that are normally well prepared because they have passed a concours to hold that position. But they may not be experts in the industry that we are debating, that the case is about. The case may be about IT, the case may be about engineering, infrastructure, and highly specialistic things, pharma, you name it, where an important degree of specific, specialized knowledge is required. In fact, in courts, it is often necessary to rely on experts' opinions. So the judge doesn't understand the matter, because it's not his job to understand the industry. His job is to understand the law. And then you have to rely on experts' opinions, which is a big gamble because eventually the case is solved by the experts and not really by the judge himself. So another advantage of arbitration is that you can seek specialized courts of arbitration for that purpose. The other advantage is the fact that you can somehow add your rules. That is, you can choose the venue of arbitration. You can choose when to go to arbitration or what type of arbitration you go to. I'll give you an example. I have a client in Vietnam that decided, this is subjective, the client said...
It's a real case, isn't it?
Yeah, it's a real case, of course. They said they are a manufacturer of sneakers. Vietnam is a pretty important place for the manufacturing of sneakers.
Yes,
now,
it is.
They said, for us, this amount of money, don't remember how much, $100,000, you name it, it's just X, whatever figure you want to put. This is the threshold between a small case and an important case. So if it is below X, you name X, it could be $1, it could be $1 million, you decide. If it is below this number, then we can go for arbitration in Vietnam. Arbitration in Vietnam is good, but of course it is not as prestigious, as tested, as known as in Singapore or other venues. So they said, if the value of the case is above this amount, then we go to Singapore. So another advantage, because it is more prestigious, because we trust Singapore more than we trust Vietnam, etc. So It is subjective, but what I'm trying to say is that another advantage of arbitration and ADR is that you can customize your case. So if you go to court in Iran, in Italy, or anywhere else, you cannot say, look, if the case is more than this, I go to this court in London, and if the case is below this amount, I will go to this court in Sweden. I'm just inventing. No, you can't. You just go to court. Of course, in most countries, you have a subdivision of jurisdiction based.
I understand. It's not adjustable.
But the level of customization is quite high, including how many arbitrators you want. You may want to have just one arbitrator to save on costs. You may want to have 3 arbitrators. You may want to appoint one arbitrator. The other one is appointed by the counterparty, and the third one is appointed by the court. You can decide. One of the advantages is that arbitration is really, really flexible.
Right, great. So if we want to talk about the disadvantages of arbitration, what do you mention? Although I think the advantages are much higher, but if you want to name some disadvantages, what do you say?
Not necessarily. There are of course disadvantages. One disadvantage is that it is normally more expensive than going to court, even though there are relatively cheap arbitration centers. Another one is that normally you cannot appeal an arbitral award. So the equivalent of a sentence is called award. So
so how about examination of an arbitrator? Don't you count it as an appeal?
Yeah, exactly. You so there is a of course there is a problem with the qualification of the arbitrators. And no, the other issue that I was pointing out is the appeal of an arbitral award. So a case is finished, you lose. In a normal court case, you can go to the Court of Appeal normally. You can appeal the sentence and say, no, look, this decision is wrong because of this and this and this and this. If you go for arbitration, normally there are some cases where you can appeal, but normally that's fine. Oh, sorry, tough luck, you lost. The only way you can challenge, in any case, an award is by challenging the legalities surrounding that. So you might say, yes, we went to arbitration and yes, I lost, but actually, I don't know, this matter was not a matter that could go for arbitration. Sorry. So I consider the arbitral award null and void, and if you want to settle the matter, we should go to court. So a disadvantage is that if you had particularly pernicious and litigious counterparties, arbitration is just an additional layer of disputes, but then you end up in court anyway. The other disadvantage is that arbitration is only applicable, and ADR in general is only applicable for certain matters, not for all matters. For instance, I'm just giving some examples, and of course there are exceptions to what I say, but for criminal law, for family law, for
government issues, I assume,
you cannot go for arbitration. So there are limits to the use of arbitration. So these are the main disadvantages that I see. Yeah, pretty much this is it.